top story. The Independent Electoral and Boundaries Commission (IEBC) and President Uhuru Kenyatta's lawyers appeared before the 7-judge bench of the Court of Appeal to challenge the High Court decision that nullified the BBI constitutional amendment process, as the IEBC argued that the High Court overreached its jurisdiction by issuing an advisory on the BBI process. President Kenyatta's team argued that the BBI popularization was done by Junet, Mohamed and Waweru, and not President Kenyatta and his handshake counterpart, Raila Odinga.
In that affidavit,
as IEBC's and President Uhuru Kenyatta's lawyers argued their appeal on the contentious issues in the 13th May High Court ruling, Tuesday's concerns of the initiator of the BBI constitutional amendment process and President Kenyatta's role in the amendment bill featured prominently in the Court of Appeal hearing.
Letter from the IEBC
with the BBI legal team revealing that former Dagoretti South Member of Parliament Waweru and Suna East legislator Junet Mohamed were the official promoters of the bill and not President Kenyatta, further raising eyebrows on the infamous BBI ruling.
My Lord, we wish to submit on this that against all evidence which was not controverted, that the promoters of this initiative was Honorable Waweru and Honorable Junet Mohamed. The court insists on finding that His Excellency President Uhuru Muigai Kenyatta was the promoter of this initiative.
According to IEBC, the High Court erred in law by giving an advisory on the BBI bill, a role constitutionally preserved for the Supreme Court.
There is nothing in the Constitution of Kenya 2010 that said you can come to court if you have no nexus with the dispute, if you have no standing, if there is no cause of action. You can write a big petition, throw it to the court and say, please help us because we are very annoyed with the action of the chief. That is not the law of Kenya.
Since you are not suing anyone, it means you are seeking the advice of the court. Can you approach the Superior Court, the High Court, for an advisory opinion? My lords, our Constitution does not allow that. You can only go to the Supreme Court, and there lies the difficulty.
However, the lawyers had a difficult time convincing the 7-judge bench that the electoral body had fulfilled the due process in the BBI signature verification exercise.
It is to be noted that there were over 4 million signatures. Not a single person, despite the publication by ABC, came out to complain that my name was put there erroneously.
Counsel,
yes, madam.
Please assist me. You see, it's my business to understand this thing. And I want to know, how is that process a verification, other than just having the numbers and perhaps ID numbers which are easy to get from IEBC, from the voters register? How does one verify that those are actually supporters?
My lords and my ladies, Section 2 of the Elections Act defines biometric to mean the unique identifiers or attributes including fingerprints, hand geometry, earlobe geometry, retina and iris patterns, voice waves, DNA and signatures. It is a fairly broad definition. Now, permit me to look at, just so that I complete that part, that is how then to apply for registration. You are referred to this need to have the biometric data and details set out in Form A to the schedule. Again, this is law.
My Lord, the learned judges of the Superior Court expended quite some considerable effort in unpacking the phrase verification of signatures. My Lord, that phrase does not exist anywhere in the Constitution. What is in the Constitution, my Lord, is a phrase which reads as follows: verification, quote unquote, verification that the initiative is supported and it continues. And it ends with voters.
President Kenyatta's team, on the other hand, came gun-blazing at the High Court judges to present 17 grounds of appeal. In their 4-point argument, Kenyatta's lawyers claimed that the president, who according to the High Court can be sued at a personal level, was not given a fair hearing, claiming that the court erred in law by hearing a matter that was determined by a court of similar status, and that the president did not contravene Article 73(1)(a) of the Constitution on the responsibilities of leadership.
So we'll adjourn now.
Now, the